The court will call the matter of HS Financial Group LLC versus LaDonna Lewis, case number 20C 1583.
Alfonso Nixon on behalf of the plaintiff, Your Honor.
Thank you. Is anyone representing LaDonna Lewis present? All right. It looks like LaDonna Lewis has failed to appear. We're here for an order to show cause today. And it appears that this was served by a Mr. Clifford DeVitz by first class mail and certified mail on February 5th, 2024, the notice for today.
Yes, Your Honor.
All right. What is your request today?
We're asking for a finding of contempt in the issuance of a bench warrant.
All right, it looks like service was effectuated at 431 Village Drive, which is the proper address. It looks like there had been some issue in the past with it going to the wrong address. This time it did go to the correct address. Defendant is found in contempt of court. Bench warrant to issue. This case for $2,884. For the judgment you have in this case. Looks like outstanding is still 2,749. Nope. Yep, that's correct. 2,000.
Yes.
749. I'll do a bench warrant for $2,800. Cash or surety. Or do you want to
That's fine. Cash sureties.
Okay. Thank you.
Okay. Thank you, Your Honor.
You're welcome. We'll call the matter of Tremaine Gibson versus, is there anyone else in the room? Peter back on.
Your Honor, I'm standing in for Mr. Boyd.
All right, one moment, please. Okay, thank you. All right, the court will call the matter of Tremaine Gibson versus Jason Atkins, case number 23C 3599.
Good afternoon, Your Honor. Nita Clipper standing in for the attorney of record, Dwayne Boyd.
Thank you.
Your Honor, we're going to ask for adjournment. We noticed when we went yesterday when I was about to fax the proof of service for Mr. Boyd that we had the wrong Zoom ID number on here for his notice. That might be why Mr. Atkins is not appearing via Zoom today.
Thank you. All right, I will adjourn. It's my next date. I can do it on May 2nd. or April 11th? Which would you prefer?
April 11th was fine.
All right. April 11th, 2024.
Okay,
One moment, I'll get your time in a second.
okay.
2:30 p.m.
What time, Your Honor?
2:30 p.m.
2:30. Okay,
Can I see you in a breakout room on an unrelated matter, please?
no problem.
All right, I guess we have to wait until 2:30 when the next matter is scheduled for. We need to wait to make sure that all parties have an opportunity to come at a timely at the time it's scheduled for, which is 2:30.
Thank you, Your Honor.
Thank you.
Hello. Oh, looks like you're muted.
I'm not. Thank you. How are you?
I'm well. How are you?
Okay.
Does it look like she's put us in a breakout room already? No. Okay.
Good afternoon. The 14B District Court is back in session. The court will call the matter of Heritage Collision and Frame LLC versus Juanita McKay, case number 23C1119.
Good afternoon, Your Honor. Mariah Fink for Juanita McKay.
Good afternoon, Your Honor. Peter Beck on behalf of Heritage Collision.
Good afternoon. So the parties were given an opportunity to try to discuss this matter and see if we could reach a resolution. Where are we with that, please?
Your
Well,
Honor-
I received some interrogatories on Monday, which I will proceed to answer. And evidently my interrogatories are incorrect, so I'm going to correct them. So once we get the interrogatories exchanged, I believe that maybe we can talk about some resolution. But there's also a problem in that supposedly my client damaged her vehicle while I was in his shop. So if that's the case, then I guess probably won't be able to sell it because I know my client's not going to pay her anything for any damages that she allegedly stated occurred.
Okay. Right, so I guess what I'm ultimately getting to is, do we need to address the motion to amend the complaint and the motion to dismiss on today's date?
Your Honor, I believe that you already addressed my motion to dismiss, and I think that we agreed that it might be in my client's best interest if Mr. Beck just amended his complaint to bring it with an actual party in interest so that she didn't have two lawsuits against her. I'm fine with that outcome.
All right, then that's what we'll do with respect to that. And as to the conversion, where are we with that one? You want me to make my ruling today? I took that under advisement until today's date.
I would like you to make your ruling today, Your Honor.
I wouldn't mind making a ruling today, Your Honor.
All right. Does anyone have any further argument they want to make as to that particular amendment? Yes, amendment.
The only argument that I would make is based on the court rule, which is 2.118 subsection 2. It indicates that leave should be freely granted when justice so requires. And I think there's sufficient evidence here to show that the defendant did receive those funds that we're claiming direct deposit to her account. That should have been paid to the plaintiff. It wasn't. She used it for her own personal benefit. And for that reason, she converted those funds. So I'm going to stick by that argument at this point.
All right, before we go any further, are either of you expecting your client to be present? We have someone who's unnamed in the waiting room.
I am not expecting my client.
And neither are you, Mr. Beck?
No, Your Honor.
All right, thank you. All right, Ms. Fink.
Your Honor, I would just point out that as stated in my response to the motion, one of the elements of conversion is that she knew that the money belonged to someone else and she kept it for her own use. At the time that Ms. McKay picked up her vehicle on April 27th of 22, her vehicle was damaged. She tried to negotiate having that fixed. It was damaged sometime between when it was dropped off at the collision center and when she picked it up. She tried to negotiate having that fixed and was unable to. And the two statements that we have that Heritage is using to say that more money is owed to them, both have a date of June of 2022. So the vehicle out date on the statement from Heritage that says that more money is due says the vehicle was left their premises on the 1st of June of 2022, but Ms. McKay picked that vehicle up in April 27th. The Liberty insurance statement that appears to show that more money is due says it was written on June 9th of 2022. So there is some confusion about those extra charges and why they would show that the vehicle was still there in June and why things would still be charging against the account. It makes sense that Ms. McKay would hold on to the money first in case Heritage doesn't cover the cost of the damage, she could use that money to fix the damage. And second, because there is this this ambiguity about these statements from Heritage and Liberty that have this June date that we're still trying to confirm.
Well, Ms. Fink, I think it was clear to me last time we were here, actually, when it sounded as though she was of some opinion that all of the matters between her and Heritage Collision were completed, and she had paid, and there was a zero balance, I think was your argument the
Yes,
last time.
yes, when she picked the vehicle up on April 27th, that is what she was told.
And when was the check received again?
I believe the check was received in February.
The check that
She only received one check, Your Honor.
okay, and so that was in February.
Yes.
So, Mr. Beck, how does that become a conversion if she gets a check in February and then she picks her truck up in April and she's told that she has a zero balance?
Your Honor, the check was direct deposit to her account in February with the instructions that with a deduction of $1,000 from $3,800, so that she then would have to take the $2,800 and give it to the collision shop along with the vehicle when she took in the vehicle. And evidently she didn't give them a check. She proceeded to leave the vehicle. They proceeded to repair it. When they asked for the money, the $2,800, they were informed by Liberty Mutual that she had been paid, and therefore they should secure the funds from her. So basically, the money was deposited to her with the intention that she was going to be paying Heritage. She didn't, and as a result of that, she converted it for her own personal use.
Well, it's not that simple. You didn't answer the question that I asked, which was when she picks her car up in April and she's given an invoice that has a zero balance, how does that make it a conversion?
Well, she said there was no zero balance. There was still the $2,800 was still supposed to be paid to the collision shop.
Is there an invoice regarding the April pickup date?
There is, Your Honor. It's the invoice that was attached to Heritage's original complaint, where they said that the total amount owed was $3,800 something, which Ms. McKay has showed has already been paid. That's what was attached to the original complaint, and that's what she had at the time that she picked up her vehicle, and they told her that there was a zero balance. It wasn't until after this case was filed that she was provided with this statement that I'm talking about that has a higher balance and a June date on it.
Is that exhibit number 1?
It's a good question. Unfortunately, my file is really scattered.
Because exhibit number 1 does have a net cost of repairs balance of $2,843.39.
That, I think you're looking at exhibit 1 to the amended complaint, Your Honor. Exhibit 1 to the original complaint has a subtotal of, I'm sorry.
17.
There's a document that shows what was owed and what was paid, including the $1,000 deductible that she paid, and it shows a zero balance. And I apologize, I can't locate that in my pile of documents at the moment. Your Honor, I think if you look in the original complaint, it says plaintiff quoted the defendant the sum of $33,843.39 for repair that needed to be done to the vehicle. The estimate of record consisting of 4 pages.
Tell me exactly where you're reading from, please.
I'm reading from page 2
Okay.
of the original complaint. So the total
What-
amount,
What paragraph number?
paragraph number 8.
Okay.
The total amount that was requested in the original complaint was the $3,843.39. It says defendant paid a $1,000 deductible, and there is still a balance owing. But then my client provided the canceled checks that went directly to Heritage, showing that they received $28,52.44 and $504.56, which with the $1,000 deductible would actually be more than what the original complaint stated was owed.
All right. Well, let me go back a little bit, because as I originally indicated, the documentation that I have, which is exhibit number 1, does show that there's 28. Every time I get to one page, there's another one before I get to the final balance. Show that there's 28, 43.39. Now you're referring to the canceled checks, which were a part of your response.
It's part of the response that my client submitted, Your Honor, before I was involved. The point that I guess I'm trying to make is that there's still some question about what was billed, what was owed, what was approved. And until that's clarified, I don't think that we can call this a conversion. Until we get some information about these June statements that would show a balance owed, and it's unclear it's unclear when those amounts were, when the work was done, when those amounts were incurred. And until we can clarify that, I don't know how you can show an intention to hold money that belonged to someone else, which is what would be required for conversion.
And I think that argument cuts against you, Ms. Fink.
Excuse me, Your Honor. Since we are exchanging interrogatories, why don't we wait until after the interrogatories are answered, and there will be a clarification as to how these payments were made, and then you might be able to make the decision as to whether or not the added count of conversion is or is not justified.
All right, let's do that. Put it off again. How long before you guys get those exchanged and feel like you're comfortable with any further argument or some real valid proofs as to what she knew at what time? Because that's what I'm trying to get to, and I think that's still murky. So, how long will you need?
I think if we could have another month, Your Honor, that would be really helpful to both of us.
All right.
Mr. Beck, is that enough time for you?
That'll be fine.
Actually, I'm going to give you until May 16th.
What date, Your Honor?
May 16th. Does that work?
May the 16th?
Yes, thank you.
Yes, that'll work. Thank you.
All right. May 16th, 2024 at what time? At 2:30 p.m.
2:30.
Yes.
Thank you, Your Honor.
Thank you very much, Your Honor. Have a pleasant day.
You too.
Bye-bye.
Bye now.
Budget Stadium Towing versus Latoya Carroll, number 23C 0224.
Good morning or good afternoon, Your Honor. David Fancher on behalf of the plaintiff.
Good afternoon. Please state your name, ma'am.
Good afternoon. Name is Latoya Carroll.
Good afternoon, ma'am. All right, we're here on Ms. Carroll's objection to the garnishment in these matters, or in this matter, Ms. Carroll. The law is very specific as to how you can attack a garnishment. I can tell you from rereading your actual objection, your argument here is that the vehicle was signed over and provided to the plaintiff in agreement, is your words, that there wouldn't be any further charges or fees. That is attacking the actual original case and the underlying matter, and you can't do that in an objection to a garnishment. It has to be one of the reasons that is on the list, or it has to be invalid for some other reason, and an attack on the actual basis for the original judgment is not one of those. Having said that, ma'am, what would you like to say about your objections?
I've actually been speaking with a detective, Myron Blackwell, who has been investigating this actual situation, and suggested that I retain an attorney, which is what I'm in the process of doing. Therefore, I can have the actual legal help in regards to that situation and their matter.
So you're requesting an adjournment today?
Yes, if possible, please.
Mr.
Your Honor, I think that you were spot on with how you started this. This judgment was entered last May. She has 21 days to move to set the judgment aside. She didn't. We've now done, so the time, even if she files that motion, I don't know that it's timely. But certainly what she put in the garnishment, and I believe there's two garnishments, Your Honor. There's a state tax garn and there's a wage garn. The disclosure that we got on the state tax garn is enough to pay off the judgment. So it was going to be my suggestion that we leave the state tax garn in place. The state doesn't release the money till the first week of April. So when we get that, we would pay off the judgment and send her anything back that's left over. But if that stays in place, we would then release the wage garn, because we obviously don't need, we won't need any more money at that point. So that would be my suggestion, to leave the state tax garn in place and release the wage garn. And like I said, if we get money, I think we know that the amount of money we're going to get from the state is $17,1942, and I think once we calculate interest on this whole thing, it's going to be somewhat less than $1,600. So she'll get probably about 120 or so back on her state tax garn, and then we'd release the wage garn.
Your Honor, I actually did receive the form. I didn't receive it until it's dated the 4th of March in regards to the garnishment from the Treasury Department. So I wasn't able to file the motion until I received that documentation, because I was unaware of this process or it being in motion until I received the tax documentation from the Treasury Department. I've recently been involved in another auto accident as well, being the fault of the other vehicle. But so I'm like, mobility wise, like I can't drive. So I filed the motion as soon as I was informed and aware that it was in place and in motion.
Right, but I wasn't talking about this being timely. When the judgment was entered in May of 2023, you have 21 days to file a motion to contest that, which is really what you're doing. You're not really contesting the garnishment, you're really contesting the judgment. And that the time for doing that has long passed.
Your Honor, this is why I was requesting the adjournment. Therefore, I could have a legal attorney who's able to advise me and what I should and should not be doing legally as far as what should be expected.
Ma'am, I understand what your request is, but the problem is twofold. One, you're talking about the vehicle title was signed over and provided to the plaintiff in agreement that there wouldn't be any further charges or fees.
Yes.
You're talking about you had an agreement with Budget Towing?
Correct.
Yeah, and
This, the exact location of which, from what the detective is still investigating, there's been other cases as well. So, with that being stated, like I said, again, Detective Myron Blackwell. I also spoke with him again today in regards to this matter, and he's still investigating. Which is why I'd like to retain the attorney.
Ma'am, I did hear all of that.
Yeah. Okay.
but may I real quickly, Your Honor?
You may.
But regardless of what she comes up with, the objections to the garnishment would still be invalid. She could at some point file a motion to set aside the judgment, but this motion would still get denied regardless of what an attorney or Myron Blackwell. And by the way, I've talked to my client and they said she never turned over the title. And I talked to the collection agency at the credit bureau, and they said, in fact, she admitted to them not turning over the title. So, but regardless, and I didn't want to bring that up because that's again talking about the underlying judgment, which is a year old. So I would request that everything happened today, that the state tax garn remain in place, the wage garn go away because we don't need the extra money. And if she wants to file the correct motion after talking to the detective and the attorney, she can do that. But this case is going to wind up at the same place, whether we adjourn it or not, because this is the wrong motion.
If today, I adjourn the motion and give her a chance to talk to an attorney, for instance, and I'm not saying I'm going to do that. Doesn't the funds just get held until that next time?
No, I think they get mailed to my
Correct.
client.
No, they actually, I spoke with the Treasury Department in regards to, and which is why I've had, as long as there is the hearing, they are willing to hold the funds there, which is why I had the documentation facts.
Ma'am, one moment, please.
I'm sorry.
Mr. Fantera, my understanding is that they're not going to do anything with this until I make a decision on the motion.
You might be right on that. I don't know.
Okay.
But again, I just don't think. This motion is going to get denied. I mean, I guess what you could do is adjourn it and give her a chance to file the right motion, but then we're opening up a judgment that's.
I'm not saying I'm going to open it up. I mean, she has to have a valid basis for that. What I want to give her an opportunity is to talk to an attorney. That doesn't mean that her talking to the attorney is going to change anything. It may or may not. But to not give her that opportunity is what I'm having a difficult time with, Mr. Fantera.
Well, except that I can't imagine what the attorney could say. What the attorney could say that would change Your Honor's mind, because everything she says goes to the underlying judgment, does not go to the garnishment. So I get what you're saying, but I just think we're going to.
Attorney could come in here next week or 2 weeks motion to set it aside, and then I have to decide whether there's a valid basis, and at least she feels heard, whether I rule against her. So, but that way, her issue of feeling as though she has a defense to the underlying matter could be heard, because the way she's putting it doesn't make sense to me.
But the thing that concerns me is in order to file a motion to set that aside, as we've all learned from the state of New York versus Donald Trump, she would have to post bond in an amount equal to the judgment in order to stay it. Which we've got the bond, it's at the state. We want them to pay it to us. So
I hear your arguments against it. I hear that. All right. I'm gonna give her the 2 weeks. Yeah, I'm gonna give it. How many do we have that day?
in a way, she's hurting herself
Yes, because the interest is going to continue to accrue on this.
Well, that not only that, but her employer is going to continue to withhold money. I was offering today to release that and send that to the court and send it to her, and she could walk into her employer and they would stop it and give her whatever money they've already withheld. Now what they're going to do, now what's going to happen is both the state and her employer are going to freeze that money. Neither one's going to give it to us, but neither one's going to give it to her.
If I may, Your Honor, I'm currently not working due to my current situation either, which is why this is already hurting me. Due to the auto accident that I've recently had. So I'm currently not working. I'm on leave of absence. And my employer.
All right. So if you had any money coming to you, I don't know if that's true or not, they're going to continue to take that out. Okay. So it looks like we only have 2:30.
We've got 2 at 2, 2 at 2:15, 2 at 2:30 because we just set another one that I think on, and then the criminal matters that we have for in person at 3.
So I'll put another one at 2:30. All right. All right. Mr. Fantera, are you available on April 11th at 2:30? Ma'am, I'm going to be as clear as I can be with you.
Yes, Your Honor.
Thank you. I'm going to give you 2 weeks. And when you come back in 2 weeks, you need to have an attorney, not adjourning this again. This is the last adjournment. And your attorney needs to have filed anything if they're filing anything by then as well. So you need to get on this right away. Do you understand? Because I'm making a ruling on this. And right now, as it stands, would be ruled against.
Can I make one more request?
Yes.
If she does do a motion to set aside, I would request that motion be filed a week ahead of time, because while I didn't respond to this objection because I felt I could do that orally, that I would want to do a reply to. So if you want to go out 3 weeks with the understanding that she has to file something within 2 and get it to me so that I can reply, that'd be or if you want to go out 2 and she has to file something within 1, I just would, if it's going to be a motion to set aside a default or not, I want to be able to reply to that beforehand.
I understand. The problem is that I'm not here in 3 weeks. In 4 weeks, I have already a full docket. So the next time you could come in would be May 2nd. And I don't think that 1 week is going to be enough time to do a set aside. So, and I don't know that she can do it. So,
But I guess the question is that if she does it, I would ask her attorney, because I think you're telling her to have an attorney, to have that attorney call me, email it to me, and I can reply, and I'll reply within 48 hours if I can.
All right.
I mean, if I have to reply orally, I will. But I always think it's better to have
in writing. I understand. So if you're going to have an attorney and they're going to file a motion, that needs to be filed as soon as possible, and your attorney needs to contact Mr. Fantera and let him know that it's being filed so that he can respond or be prepared to respond orally when he gets here in 2 weeks.
Or they can call me and we can maybe resolve this case short of that. You know, I mean, it's always possible to you know, cut the amount and just cut to the chase. So she's got my phone number. I hope, Miss Carroll, do you have my phone number?
I believe it should be listed on one of these documentations here.
You have the notice to appear?
Yes, I do.
My phone number's on there. So if you get an attorney and he wants to talk, have him call me, please.
Is that the 734-417-1336?
Yes, ma'am. Your Honor, what time did you say on the 11th?
2:30.
All right.
Right, thank you.
Thank you, Your Honor.
Thank
Your
you.
Honor, have a good holiday weekend.
Thank
Both
you.
you- Both you and Heather.
All right, thank you.
Thank you as well. Thank you, Your Honor.
Thank you, Ms. Carroll.